Welcome to the Melinda Eitzen Show. I'm Melinda. So you're going to be a witness. We have with us today Marilea Lewis, who's my partner, and we're going to talk about when you are going to be a witness. How do you prepare and what do you do? What makes a good witness? Welcome, Marilea.
Thank you, Melinda. Delighted to be here. What makes a good witness? Someone who can answer questions. Someone who can answer specific questions. So it depends if you're just a witness, third party, don't have any interest in the case other than you saw something or you know someone, or whether you're a party. Irrespective of your position, whether you're third party or a party, the answers are going to be pretty much the same. Listen to the question.
And you have a lot of experience in the courtroom in two different ways. So for those who don't know, tell a little bit about your background.
Well, I am a partner at Duffee Eitzen, where I'm delighted to be involved with wonderful folks, such as Melinda. But prior to that, from 1986 until 2010, I was a judicial officer, serving first on a juvenile bench for 6 years and then on a family court bench for the remaining 18 years.
So you saw a lot of witnesses.
I saw a bunch of witnesses.
And
yes.
now you're a litigator, big
Yes.
time. So you're calling witnesses and having them testify. So this could be a tutorial for those who might be our witnesses or someone else's. But listen to the question. That sounds so simple, but it's obviously not. One thing that I tell people is, in normal conversation, we talk on top of each other, right? You can't do that in the courtroom.
You can only do it for a limited time, because then the judge and or the court reporter are both going to call you down. Because the court reporter is taking the testimony because you're under oath. And so she can't take down two people or three people or however many people happen to be talking at once. So somebody's going to stop. Somebody's got to stop. And ordinarily when the court reporter does this, somebody stops.
That's a good sign.
Yes.
I can't do this anymore. So that's a key. So what's another tip?
Well, when I say listen to the question, we all perceive things differently. And truth is perception. So if I ask a question and I might be going for a specific answer and the witness is, somewhere else, they may answer, but it's what we call non-responsive. How many children do you have? Well, let's see, the first one was born, no. The question is, I have two. Okay, the next question would be, and when were they born or what are their ages? But you listen to the question and you answer the direct question. And as I always tell my clients, don't volunteer information, especially if it's information that you haven't shared with your attorney.
That's particularly the wrong information.
That's right, because the worst thing that can happen is the attorney learns something somewhat incriminating from his or her client while they're on the witness stand.
Yeah, that's the worst for sure. One thing I tell people to prepare them is, if you're asked, do you know what time it is? The answer is not 3 o'clock. The answer is yes or no.
That's right. And then don't tell us how to build the watch or the clock.
Exactly.
What time is it? Yes.
We're also under time pressure sometimes.
Most of our judges right now, at this point in time, have time limits, simply because the dockets in Dallas and surrounding counties are so heavy. So you're going to be limited to the evidence you can present. So it helps when your witness knows that that's a consideration and can tailor their answers to that.
One thing to think about is, it's different if you're asking your client things on direct than if the other side is asking your client things on cross. And you might coach the client differently on how to think about their responses.
Certainly. But you always want them to be honest.
Honest, number one.
Number one, always. In fact, many people don't know that if an attorney knows their client is going to not be honest or is going to intentionally lie on the witness stand, the attorney is obligated to withdraw. The attorney cannot put a client or a witness on the stand knowingly that there's going to be lying done.
Yes, no lying.
No,
We're not
no
allowed
lying.
to proffer the lying. But you can tell the truth in a better way or a worse way.
That's true. That's true. If the question is, did you have anything to drink last night? And the answer is yes, I did. The answer is not, oh, I only had 6.
Right.
No, the answer is yes, I did.
Don't offer extra.
That's right. Don't expand. your
Especially
answer.
on cross. So direct, there might be more of an open-ended question, right? Meaning you're asking your own client questions. That might be when they're telling their story a little bit more.
Right, because you are limited as the attorney on direct. You can't ask leading questions. Whereas if it's cross-examination and I'm crossing the other party or one of their witnesses, I can lead them all day long. But I have to have very specific questions that are non-leading on direct examination. So that's why you've got to be prepared and got to let your attorney know anything that might be germane to the issue. If you've had, I don't know, trespassing conviction in the past, and the attorney says, have you ever been convicted of an offense? It may have been a Class B, but you were convicted, unless it was expunged. So the honest answer is yes. And be prepared for the other attorney to say, well, was that the time you were trying to break in my client's house? you just got to be prepared. And so if the attorney knows about it, then you can handle it much more effectively. So listen to the question. If you don't understand the question, there's no harm in saying, can you please rephrase it? I don't think I understood it.
Oh, and sometimes lawyers do ask a convoluted question because they're trying to get around a rule. They know they're going to pull an objection.
Absolutely.
And so they think, if I just ask it kind of in a convoluted manner, they might just offer up what I'm trying to get at anyway.
Right. And, sometimes I listen to questions being asked by opposing counsel and I'm thinking to myself, I didn't understand that question. So,
Right.
So, for example, one of my classic examples, many years ago, I was on the bench and there was a dispute about a gentleman's roofing and how much he had charged for the roofing. And the attorney said to this gentleman, do you charge by the shingle? And he said, yes, I do. And she said, well, how many did you lay? And he looked kind of confused and he looked around and he said, well, all of them. And she said, objection, non-responsive. And I said, well, actually, no. That was responsive to your question. She thought about it a minute. She went, how many of the number? Can you tell me the number of the shingles? So, you listen to the question. Bless his heart, he answered the question honestly and responsively. So listen to the question, answer honestly, and if you are a party, if you have something you've got to get out into the world and it's not pleasant, be sure that you've told your attorney so that your attorney can then come back and try to rehabilitate or minimize that particular line of questioning. If you're a third-party witness, you really don't have that kind of preparation.
Right. And preparation's a lot of the name of the game, right? I think that some lawyers, they're very busy. We're all very busy running around, litigating, collaborating, whatever we're doing, mediating. And sometimes lawyers are not as intentional as maybe they should be of setting time aside to get their client ready to testify. And they can do a little practice round. That's all protected by attorney-client privilege. And then they can find out that there's some skeleton in the closet,
Absolutely.
hopefully.
Absolutely. And of course, it's not Perry Mason. I love to watch Perry Mason because, Perry's on a murder charge case that's like death penalty, and he walks into court with a legal pad.
Right. You're like, where are your boxes?
Where's
Where are
the
your
rest of your
documents?
where's
Don't
your
you have
evidence?
exhibits?
And with that, he gets somebody to confess on the witness stand. It doesn't happen that way, and it really, certainly witnesses can get into trouble when they overthink it. One of the things I tell them is don't try to think about or figure out where the counsel is going with the questioning. Listen to the question, answer the question honestly, but don't try to find the trail that this attorney is going down, because that's really not going to do you any good, because then it's going to just confuse you and you're going to have real difficulty. It's so much easier for people to tell the truth. It's when they start trying to fabricate evidence or color their answer that they forget what they said 5 minutes earlier. And
People can't carry the lie consistently.
that's correct.
So they might as well tell the truth because they're going to be shown out as being a liar. On the preparation side, one thing that I tell the client is on cross, the other lawyer's asking them the questions, don't blurt out something you're worried about them asking, because that's what happens. They think, oh, I'm worried they're going to ask me XYZ, and so they hear that question when it hasn't even been asked.
That's right. They telegraph that to opposing counsel.
Right. Like, hey, be aware that's a thing and don't do it.
Because if you just give a little bit of information, then somebody's going to pounce on it. Dr. Michael Flynn and I did an article for the Texas Psychological Association about being an expert witness, and that's a little bit different because you are there to share your expertise. So experts, a lot of the experts get anxious because they're going to be offering an opinion that's going to be very, very relevant to the subject matter that the court's going to be deciding. And I always tell them, stay in your lane. Don't get caught up in whatever questions are being asked if that's not what you're tasked to do. If you're tasked to do a specific thing, do that. But don't let the attorney pull you in on something that's not part of your expertise or part of your court-ordered responsibility, because then you do tend to lose credibility.
Yes.
And you dilute your own expertise.
Yes. So I think that one thing that irritates me is if an expert just collapses, right? So they have an opinion, they've said it, and then when they get attacked by the other lawyer, they just melt into a pool of, by the end of it, they're agreeing with that lawyer, right? Oh no, forget everything I just said. So I don't like that. But sometimes they can go the other way and be too extreme in defending their position.
Correct.
When they could just say, I didn't have that information. That could affect my opinion. I don't know,
And there's nothing wrong with saying, I don't know. If that's the truth, then say it. If someone says, how old are you? And your answer is, I don't know, that does call into question your credibility. I mean, right off the bat.
How your mind is working.
You don't know. Well, what's your birthday? I don't remember.
That doesn't work out.
You got some problems there.
And that's irritating to the court when people are so intentionally evading. And that happens in depositions probably more than in court. But the judge can read the deposition eventually. That could be put before the judge. So don't be like Bill Clinton, I didn't inhale,
And one of the things that the court can do to a witness on the witness stand, which is not a good thing, is admonish the witness. If a witness is being intentionally evasive, then after 2 or 3 rounds of, I don't remember, I don't know, I don't understand, and objection, non-responsive, the court can say, ma'am, sir, answer the question. Do you understand the question? If you don't understand the question, say that. But you need to answer the question. And I've seen some witnesses just kind of fall apart at that, because it's one thing to have the attorney asking questions and they're thinking they're ahead of the game. And then when the judge steps in, it can really impact the rest of the testimony. What I've seen frequently is witnesses who've taken the stand and just done a great job testifying for the attorney that put them on the stand. But then when the other attorney starts asking questions, they can't remember, they don't know, or they don't speak the language any longer. Then all of a sudden it comes out that English or whatever isn't their first language, and all of a sudden they don't understand a single question, but they understood all the others. Again,
Loses credibility with the court.
loses credibility, doesn't help anybody, doesn't help the party they're testifying for, or doesn't help themselves if they are the party testifying. So things to consider. I think the first thing we ought to think about, though, is what do you do when you receive a subpoena?
Yes. Yes.
That's how you know you're going to be a witness.
Yes.
Don't panic. Don't panic and don't ignore it. That's the worst thing you can do. If you're a third-party witness and you're just a fact witness, call the attorney and say, what do you think I know about this case? If the attorney doesn't call you first. But that's how we get third-party witnesses.
Sometimes it's the only way we can get their attention. I've had cases where I'm trying to reach out to them and have a conversation about that, and they won't call me back. But when they get the subpoena, they suddenly will call me back.
Absolutely. Absolutely.
And I may not even want them once I know what they know or don't know. I just need to know. What do you know?
Right. And that's the thing. As you say, it may just be an attention-getting device just so you can get them to tell you what they know. But it's interesting to me how many people tend to forget a lot of information once they receive that subpoena.
They're like, who are those people again? I've never heard of them.
I never heard of them. Well, they've been your next door neighbors for the last 10 years. So, so people shouldn't really try to avoid it. It's like jury duty.
Yeah.
We're not going after the witness. We're just trying to present a case with as much information as possible so the judge can make a just and right division or make the appropriate orders for the children.
Yes.
So if you're going to be a witness, don't take it personally.
Yes. We're not attacking you.
We're not attacking you. And if you've got an opinion, that's fine.
Yes.
Yeah.
We want good information for the court because otherwise it can just be a he said, she said, right? If it's a divorce, the wife and the husband are both up there saying, no, I'm the one who does blah, 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 blah. Oh, no, he's horrible. He yells at the kids. He coaches their team and then he gets kicked out, whatever. If we can have third parties come break the he said, she said, that's helpful to the court.
Absolutely. It's what your client needs to get their story out. So it isn't something personal. And that's why I would advise anybody who gets a subpoena, you're going to know who's subpoenaing you because it's on the subpoena.
Right.
Call the attorney. Say, hey, I got this subpoena. I don't know what you want me to talk about. That isn't coaching. That's just saying, my understanding is that you, as I said, the next door neighbor or you're the coach, you've had some personal interaction. And of course, that's a little bit different if you're just a lay witness or a third-party witness than if you're an expert witness. Because if you're an expert, you're going to be there for the purpose of providing your expertise. Now, of course, if you are, say, the child's pediatrician, while there is some HIPAA protection, you don't have the same HIPAA protection as a party would, an expert would, if that's the marital counselor.
Right.
Because then you've got two parties who both have to release you for purposes of their testimony. So again, it goes back to somebody needs your testimony and your knowledge for some reason.
Now, are there instances where the witness might hire an attorney themselves?
Oh, yeah. There are many. For example, if an issue is income and all of the tax returns have been submitted and they've all been prepared by the same CPA, and so one party or the other subpoenas the CPA to the witness stand. Well, of course, most of them are going to say, well, you have the documents, what is it you need? Well, what I'm going to need to know is, did you know about this, and this? And the CPA is like, let me talk to my lawyer. And they will hire their own lawyer because, of course, anything that they say under oath could potentially have some repercussion further down the line. So, yes, some people hire them unnecessarily simply because they've never been subpoenaed and they're really concerned about appearing in court. So it's not necessary, but certainly anybody has the option to hire an attorney to represent them for any appearance in court.
I help a lot of mental health professionals just know what to do when they get subpoenaed, just because we need you mental health professionals out there. So we want them to not be afraid to go to court or unwilling to help families that may need somebody to go testify because the court needs the assistance. So I don't want them all freaked out, so I started running around and doing a little talk about what do you do when you get a subpoena, and when is it a HIPAA issue and when is it not, and how do they handle it? But the bottom line is this: they either need the clients, whoever their client was, to sign a release, a HIPAA release that allows them to testify, or they need the judge to instruct them to testify. And they shouldn't testify until one of those two things happens. And I tell them, bring your file if it's been subpoenaed and clutch it to your chest until the judge says, no, I'm ordering you to do it. Because that's similar to getting release. If they can't get a release, a judicial order, but they have to wait till they see the judge. The subpoena itself is not an order.
Correct. And another thing for experts or anybody, if you get subpoenaed and you're on a cruise that day, you can call the attorney and try to make alternative arrangements.
Yes, I had that happen recently, and I really needed the testimony, but I just took a short deposition instead because she was going to be in Europe. So we said, well, obviously you're going to Europe. We're not going to interfere with your European vacation. But we took a little short deposition, and that captured her testimony, and then we just read the deposition in at trial. So there's ways to accommodate.
That's true. And so when you receive that subpoena and you're going to be called as a witness, that's another reason why it's important to get in touch with the attorney who subpoenaed you, because there can be arrangements made to do it remotely by Zoom. Some courts will allow third parties to appear by Zoom. So, or Teams, or I don't mean to, pick out one platform.
Some electronic platform.
That's right. An alternative to being in person. So you have to, ordinarily though, the courts have to be made aware of that before the day that you're supposed to testify. So if you're subpoenaed to appear in court on April the 7th, but you're going to be at Disneyland that day, you don't wait until the morning of April the 7th and say, oh, just give me a call because I'm in California.
Yeah.
You need to let the attorney know. And of course, there are vehicles and procedures that one can follow to quash a subpoena or do all of those other things. But you don't have to hire an attorney to do that. The best thing to do is just reach out to the attorney who subpoenaed you.
We know the judge is not going to make somebody miss their European vacation.
Or their child's graduation,
Right.
or.
So we have to work with them.
That's
and
right.
We want to work with them because we really do want their testimony. We don't want them to just no-show on the day. That's kind of the worst circumstance. If someone does no-show and you really need them and you're going to have another day of trial that you could try to get them to, what could happen?
Well, not good things could happen. The judge can issue a capias or a bench warrant that directs them to be picked up because they were duly served and made no response. So just ignoring a subpoena is never the right thing to do.
That would be so embarrassing, have the sheriff come pick you up.
Especially
Excuse me, we're going to court now.
Especially if they know where you work.
Yeah, it wouldn't be that hard to find them.
That's right. So you don't ignore a subpoena. But the thing to remember is you're a witness. You're there to provide information to the court. You are not there for the court to in any way judge you or your testimony. You're just there as an aid to the court.
Are there some witnesses that could be paid for their time?
Oh, experts are paid for their time all the time. And that's really not a bad thing. People say, oh, well, you were paid to testify, so you must be, in favoring the person who paid you. Not necessarily. Experts expect to be paid, and they ordinarily will say, if you subpoena me, I will appear on that day. Just keep in mind that my hourly rate is, and that's something you have to factor as the attorney, factor into the witnesses is how much is it going to cost the client?
I've noticed that some experts have a higher hourly rate to testify than they do for their other tasks in their job.
Well, of course, because they have to drive to court, and they're not, just because they're subpoenaed at 9 doesn't mean that they're actually going to go on the witness stand at 9.
They're not dying to testify usually either. I think it's a little bit of a discouragement. You better really need me.
I've testified, and it is, it's not a pleasant experience because you never know how your testimony is going to be perceived. So, and I've been in and out of courtrooms for many, many years.
Yes.
So sitting up there on the witness stand, it is kind of intimidating, even if you know why you're there and you know everybody in the room and you know what the limitations are. It's still intimidating. So for third parties who've had no experience and they really don't want to be involved, it can be very, very unsettling. That's why I would suggest that anybody who is subpoenaed call the attorney.
And as a lawyer, lawyers could be listening as a little coaching moment for the lawyers. In most instances, when it's appropriate, you can provide the questions even in writing to the witness that you plan to ask them. And that's helpful because it helps them calm down. Okay, this is what they're going to ask. And sometimes I'll send the questions and say, tell me if there's anything on this list you don't want me to ask.
Well, and if they have some idea of the purpose for which they're being called, that really helps. The concern that I have with some witnesses is they then memorize those questions, and if you don't ask the exact question, they don't have an answer, and they've got this deer in the headlight look like, where was that on the list?
Yes, we do vary. We might vary because we have to respond to what's happening in the courtroom. And we may have already had something happen in the case where we know the judge doesn't care about X, but really wants to hear about Y. So you're right. I should say, and this isn't a script. This is an idea.
These are suggestions
of the area I'm going to want to cover with you, but I also want to know if they're like, don't ask me this because really that didn't occur in this situation, or you're not going to like the answer in that situation.
And that's another thing that's always helpful, because if you have your client saying, on Saturday, this happened, and then you call the witness who was right there who said, no, it didn't really happen that way.
Yes.
It goes back to perception. The client may have perceived it one way. Someone who isn't intimately involved, but who was just an observer, may have observed it entirely differently. And so that person isn't going to help you. But if your client's saying, oh, this person's going to back my story 100%, he was there, he saw it, he knows what's happening, and you wait until you put that witness on the witness stand to find that out, it's going to be difficult for everybody.
They say, don't ask a question you don't know the answer to.
Absolutely.
We've all been like harshly reminded of that, haven't we?
We have. Uh-oh.
We have an alarm. Something's
do.
reminding us that we need to finish up, I think. Wrap it up. Time to wrap it up. So for those witnesses out there, the takeaway is, don't freak out.
Don't freak out.
Call the lawyer.
Call the lawyer.
Listen. Be a good listener.
Answer only the question you are asked.
Don't provide extra information.
Don't go into a narrative. Be direct, be honest, and be relaxed.
And you can call a lawyer. You can hire a lawyer if you need to. You don't always need to, but you have a right to. You can try to quash a subpoena on your own, but you certainly can just call and say, hey, work with me. I'm going to Europe.
But don't ignore it.
Don't ignore it. Number one, don't ignore it. Thank you so much for being here, Marilee.
Thank you. I enjoyed it very much.
Pleasure.
Thank you.
Thank you so much for watching. Please join us again on the Melinda Eitzen Show.